I suspect that many people who are passing by have at some point in their careers been made redundant. Since the financial crash in 2008, the banks and other financial institutions have undergone a huge amount of restructuring. There's been a lot of cost cutting, there's been a lot of regulation, and no doubt a huge amount of employees have been affected. When employees are made redundant, they're often presented with settlement agreements. Now, a settlement agreement is an agreement usually between the employer and the employee, whereby the employee waives their rights to bring certain claims in the employment tribunal on the basis that the employer offers a discretionary termination payment. It is a requirement that the employee obtains independent legal advice on the terms of the settlement agreement and on its effect on the employee's ability to bring claims in the employment tribunal. Sometimes the first £30,000 of a termination payment can be tax-free, but you ought to discuss this with your advisor, as that isn't always the case and there are a number of exceptions. There are other things to watch out for too. For example, you may wish to consider whether a reference is agreed as part of the negotiations. Sometimes a reference can be attached to the settlement agreement. Another thing, it may be that you have restrictions in your employment contract, and as part of the negotiations, you may be able to get those restrictions waived and specific reference to them being waived in the settlement agreement. Then there's another issue such as bonuses, and it is always sensible to discuss bonuses with your advisor, because it may be that there needs to be reference to bonuses in the settlement agreement. And for example, if you have deferred awards, they may need to be looked at as well. If you are given a settlement agreement and need advice, please do contact me and I'd be very happy to advise you.